Hi guys, welcome back to Prospect Channel TV. Thank you for always coming out here. May God bless you all. Human rights lawyer Femi Falana San has warned that the Nigerian government's argument that there are pending charges against the detained leader of the indigenous people of Biafra, IPOB Nnamdi Kanu, at the Federal High Court was a contemptuous mockery of the Court of Appeal's judgment, which is binding on all authorities. Falana warned that the President Muhammadu Buhari-led Nigerian government should not twist the judgment of Court of Appeal on Nnamdi Kanu. Sahara reporters had reported that a three-man panel of Appeal Court justice had on Thursday upheld the appeal of Nnamdi Kanu, which sought an order of the court to discharge and acquit him of remaining 7 current charges bordering on treasonable against him. Kanu had in his appeal dated April 29 and marked CA/ABJ/CR/625/2022 applied to be discharged and acquitted. Kanu was first arraigned on December 23, 2015 and was later granted bail on April 2017. The Court of Appeal, in upholding his appeal, discharged him of all the charges and further declared as illegal and unlawful his abduction from Kenya to Nigeria and quashed the entire terrorism charges against him by the federal government of Nigeria. Shortly after, the federal government, through the Attorney General of Federation and Minister of Justice Abubakar Malami San, interpreted the judgment and said that Kanu was only discharged but not acquitted. Reacting to the instance, the federal government that the IPOB leader had pending charges in court, Falana said that the Court of Appeal's judgment was binding on all authorities and persons in Nigeria by virtue of Section 287 of the 1999 Constitution of the Republic. In a release, Falana said, in the case of Nnamdi Kanu versus Federal Government of Nigeria, the Government of Nigeria, the Federal High Court had upheld the preliminary objection of the defense team, led by Chief Mike Uzekome San, and dismissed 8 out of the 15-count charge against the defendant. In his judgment delivered yesterday, the Court of Appeal dismissed the remaining 7-count charge and discharged Mr. Kanu on the main ground that his rendition in Kenya had rendered the entire proceedings in the Federal High Court legal under the Nigerian Constitution and other international law. Consequently, the Court of Appeal ordered Mr. Kanu's immediate and unconditional release from the custody of the State Security Service. Therefore, the claim of the federal government that there are some pending charges against Mr. Kanu in the Federal High Court is a contemptuous mockery of the Court of Appeal, whose judgment is binding on all authorities and persons in Nigeria by virtue of Section 287 of the 1999 Constitution of the Republic. Kanu had been rearranged before a Federal High Court on amended 15 counts bordering on treasonable felony preferred against him by the Nigerian government. However, on April 8, Justice Binta Nyako struck out 8 of the 15 counts, while ruling on the preliminary objection seeking to quench the charges. The judge said count 6, 7, 8, 9, 10, 11, 12, and 14 had not disclosed any offense against the defendant, Kanu. The charges that were struck out below as follows. Count 6, made broadcasts to attack officers of the Nigerian police force. Count 7, made broadcasts in which he incited members of the public to hunt and attack officers of the Nigerian police force. Count 8. Made broadcasts in which he directed members of the IPOB to manufacture bombs. Count 9. Made broadcasts on the various states in furtherance of terrorism against the Nigerian state and with intent to destabilize the fundamental political and economic structures of Nigeria. Incite members of the public to stop the Anambra governorship election. Count 10. Incited the members of the public to destroy public facilities. Count 11. Threatened members of the public not to come out on the 31st May 2021. Count 12. Made broadcasts with the intention to incite members of the public to stage a violent revolution in furtherance of acts of terrorism. Count 14. Directed members of the public to destroy the public transport system in Lagos, resulting in major economic loss to the governor. Iyako had said that count 1, count 2, count 3, count 4, count 5, count 8, and count 15 showed allegations which the defendant had to answer. However, Kanu, through his team of lawyers led by Mike Uzeko-Mensan, filed an appeal marked CA/ABJ/CR/625/2022, praying the court to quench the remaining 7 counts for being devoid of merit. Oh my God, Nigeria not get shame. Shameless people. The judgment means that Buhari and Malami are international kidnappers. APC and its leadership don't have spirit of God in them. Anybody campaigning for APC to come back again needs to go for medical checkup. Malami is not trying to twist the appeal court judgment. You don't even know what happened there. We have to hire a private teacher for him. Malami is one of the few disadvantages of quota system. For sure, they won't release him. For sure, Biafra is here. Stay safe. Okay, guys, these are some reactions by Nigerians. Let's hear from you. Kindly share your thoughts below the comment section.